Beattie Butler came and asked me to introduce him today, and I thought, shit, I really don't like Beattie Butler. I thought that was going to be a problem, because in reality, we're opposite. He's smart, he's aggressive, he's young, he's dedicated, and he's talented, and we're all lucky to have Beattie Butler.
Pictures, huh? All right, I want a cut of whatever you sell them for. I'm sure they're going to go for a lot on eBay or whatever else. So, I want to talk to you about a kind of lawyer, a lawyer that I call A.W. Shucks. And he's not real, but he's made up of people that I've observed over my years as a lawyer. And I say A.W. Shucks because he's always all shucks. And he's really good in front of a jury. And he's never overly lawyerly, probably because he never knew how to be, but that's okay. He speaks the everyday language of the juror. He's folksy, laid back, calls everybody sir or ma'am, no matter who they are. And he's good at using metaphors appropriately, even if they are all about hunting and fishing and possums and growing beans or some shit. And he's a straight shooter and he tells it like it is. And I just talk to him like I'm at a church barbecue. Fix you a plate. And fix a plate doesn't mean you got a plate that you need to glue back together. And all the food's hot and the drinks are cold. And jurors like him, and they should, because he's simple, right? But he almost sort of prides himself on this anti-intellectualism. As if he's Larry the Cable Guy or something. I got no time for your fancy book learning and $5 words, you know. I just know how to speak from the heart. Well, I'm here to tell you, I fucking hate lawyers like that. I really do. And it's not because he probably parks his pickup truck next to a Mercedes. I don't care. And it's not because he probably lives in the suburbs or in the city and not on a ranch or a farm. I don't care. That's fine. I don't know if he's ever roped a steer. I doubt it. You know, or milked a cow, but I doubt it. But I don't care. I hate him because he is a walking, breathing Sixth Amendment violation. And there's nothing wrong with being folksy, if that's who you are. And I come across the all shucks as just because I'm from the South. I'm sure there's a New England version of all shucks. I'm sure there is a California version of all shucks. I feel certain there's a Midwestern version of all shucks. Because you say to him, A.W., why didn't you object when they were doing that shit to your client? Well, I don't like objecting because I think it offends the jury. Well, why did you let the prosecutor shut you down with objections that were without merit? Oh, I thought that the jury, he was offending the jury. I want him to know everything. I got nothing to hide. I hate him because he doesn't prepare, first of all. There's a part of all shucks as a lawyer, I know. When he's called for trial, he says, Judge, I got my legal pad, I got my pen, I've taken the cellophane off the legal pad, I'm ready to go. He thinks he can charm his way into an acquittal. But it's really an excuse for laziness, is what it is, okay? And, you know, it's almost like, who's this guy that just paid a bunch of money to play basketball? LeBron. You know, no matter how good LeBron James is, if he walks every time he gets the ball, he sucks, right? And who's a real good running back? I don't know. Somebody.
Adrian Peterson.
Adrian Peterson, of course. I was going to say Walter Payton, really date myself. That person, no matter how good of an athlete he is, if he moves before the ball is snapped, does that be in legal procedure or something? He sucks. And, you know, what I think that we, in our attempts to try to make sure that you don't sound overly lawyerly, I want you to understand that, at least for me and I think for most of us, that doesn't mean that you ignore the law or forget the things that you learned in law school. We just want to redefine what it means to be a lawyer, okay? Because of this, I'd like to tell you that you'll never be in what is the darkest moment for a criminal defense lawyer. And I hope that you never do find yourself there, but you almost certainly will. And it's this moment. It's after weeks of preparing, if not months preparing for a trial, and being in trial for weeks for a client that you think might be innocent, but at the very least, the evidence shouldn't prove him guilty, and you haven't slept, you haven't eaten, you've hugged the toilet dry heaving what you couldn't get down your throat, and you're sitting there thinking, while the jury's out, what am I going to tell his mother when they take him away? And when he's convicted and his kids and grandmother are wailing in the courthouse halls, if the best you can say is, hey, we gave it our best shot, man, that is meaningless to him. It is meaningless. And I have been there, and it's terrible. But you never want to be able to say, I gave it my best shot, even if you did. I'm sorry, even if you are. You know what you want to be able to say? The only thing that you can say to him at that moment, we've got some issues on appeal. And if you can't, if the lawyer that can't say that, all shucks, just wasn't our day, he sucks. And I can't stand it when I see people like that. You know, because you know who doesn't care about your ability to emote appropriately? Your ability to make the jury laugh or cry or feel for your client? You know who doesn't care about your ability to be in touch with the common man, whatever that means? The record does not care. The record doesn't care, it doesn't care, the record does not give a fuck about your trial skills. And all of what you've done, all of what you learned here is for nothing. Because trials really are rarely in your client's best interest. You know, being a good trial lawyer helps your client because the threat of trial hopefully means that you don't have to go to trial. So if you're not adept at making a record, creating a record, preserving a record, your abilities as a lawyer, everything that you've done up until the time you get the verdict is for nothing. And so what I want to try to talk to you about today is how you can use the rules to your advantage to make sure that that inevitable moment where you're down with him in the holding cell, you can say, you know, we've got some issues on appeal. Okay? So, look, you shouldn't be intimidated by the rules of evidence. Is this dark? Can people see this? Okay. You know, the rules break down into three categories. The 400s are about relevancy and prejudice, and character evidence, which is more or less just relevance and prejudice revisited. Okay? The 600s, impeachment and writings, and the 800s are hearsay. You know, that's the basic way the rules break down. And so we're going to talk about those today, and I'm going to do that in reverse order. I probably won't get to everything. The other thing is, we're going to talk about is how to constitutionalize and federalize issues when you preserve them. Confrontation clause and new limits, and motion and limiting, effective objections, when to object and how to object. So, let's start with hearsay. I want to give you some practical advice on hearsay. Not every answer from a witness that begins with, I heard, or he said, or she told me is hearsay. It's a knee-jerk reaction. Prosecutors hear the witness go, he told me, he said, she said, and they say hearsay. It's not always hearsay. That's practical lesson number one. We're going to talk about that. Practical lesson number two. Just because an answer from a prosecutor's witness does not begin with, I heard, he said, she said, he told me, she told me, it doesn't mean that the answer is not hearsay. Okay? If you think those are the magic words that dictate what applying the rule should, what results should follow, then you're wrong. Okay, I hate it when I have to do this. This is the definition. Hearsay is a statement other than the one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Let's break that down, because there's so much that you would like to use that's not hearsay because it doesn't even meet that first criteria. It's not even a statement. Okay? Not everything that a person says is a statement. For example, well, I wish the rules didn't do this. A statement is an assertion. They define it as an assertion. But it's an assertion which can either be true or false. Otherwise, it could never be offered for the truth of the matter asserted. I wish they'd use the word proposition. I'm falling back on my philosophy background. A proposition is a statement that corresponds or fails to correspond to some fact. The cat is on the mat would be a proposition. I was in Boston when the murder happened. If the assertion cannot be either true or false, it's not a statement and could never be offered for the truth of the matter asserted. Ouch! Can never be a statement. Do you know what time it is? That's not a statement. Can never be hearsay. Bring me the shovel now if you know what's good for you. Not a statement. Jimmy Page off smack was the greatest guitar player, second only to Hendrix, arguably. It's not a statement. It's an opinion. The Giants suck this year like always. If you look at me that way again, there's going to be trouble. Not a statement. Can't be true or false. Give me a fucking break. Can't be true or false. It's not a statement. So you don't even need to figure out, you know what, almost all of those, if they were relevant, you could come up with some reason as to what they were offered for, probably the effect that it had on the person who heard them, but you don't even have to get that far. It can't be true or false, so it can't ever be offered for the truth of the matter asserted. So if someone said, he told me, bring the shovel now if you know what's good for you, it's not hearsay. So the first question, can what was said be true or false? If not, it's not a statement and can never be hearsay. Not all statements which can be true are offered for their truth. So that's the second step. Let's say that it is a statement, something that can be true or false. For example, the victim says, I've got a gun. Might not be offered for the truth of the matter asserted, but for the effect on the person who heard it, like in a self-defense case. Or, I heard the victim tell the defendant, quote, I live on the corner of Sumter and Perry Street. Not offered to show where the victim actually lived, but that the defendant knew where he lived, maybe to give him opportunity or something else. So, is it really a statement? If so, is it really offered for the truth of the matter asserted? And the third question is yes to one or two, then does it fall into one of the exceptions? I am not going to go through all the damn exceptions, y'all. So, practical lesson number 2, disguised hearsay. Where I was saying that, I sworn I brought some. Where the prosecution tries to disguise hearsay by not asking what the witness said. Usually goes something like this. Well, hold on, I'm not there yet. Other than one made by the declarant while testifying, all right, so statements by the witness can still be hearsay. I've got ahead of myself, I'm sorry. A statement where the witness is also the declarant is still hearsay, okay? The witness is on the stand and says, I told so-and-so, thus and so. Just the fact that the witness is on the stand and the declarant is the witness doesn't mean that it's not hearsay. If what he said that he told someone is being offered for the truth of the matter asserted, it is hearsay. You usually see it this way. God, this drives me nuts when I see prosecutors do this and all shucks doesn't object. I saw him do it, and I told the police the same thing. Or prosecutors even just know what they're doing, shameless. And say, what you've told us today, Mr. Witness, did you in fact not give a written statement to the police where you said the exact same thing? All shucks sits on his fucking hands. You know why? Because, well, you know, he's on the stand, I can cross him. That's confrontation. We're going to talk about that in a minute. It's still hearsay. It doesn't matter what the witness is repeating. That the witness is repeating not what he heard, but what he said. It's still subject to a hearsay analysis. This is an attempt to bolster the witness's in-court testimony by having the witness repeat what he or she told someone else, usually the police. I just did that. Yes, I did tell the police that. I told them I saw the defendant leaving the scene with blood on his clothes, gun in his hand, and a smile on his face. I told him, he said, I'm glad I killed him. It fits the definition of hearsay because the declarant said that outside of court. He's saying what he told the police. And it's offered for the truth. Doesn't matter that the declarant's witness. Look, and if you have to find the rule that helps you with this, 801D1B. A statement is not hearsay if it is a prior consistent statement offered to rebut an express or implied charge of recent fabrication or improper influence or motive. And that's the only time that it's not hearsay, okay? So, if, let's see. For example, somebody offers an alibi. I saw the defendant at the movie theater on the date and time of the murder, right? Cross. Well, isn't it true that the defendant is your boss? And that would go to bias, right? Yes, he is my boss. That cross-examination has alleged an improper motive or reason to fabricate. But on redirect, was the defendant your employer at the time of the incident when you first gave your statement to police? No, he wasn't. What did you tell them then? That the defendant was at the movie theater at the time of the incident. That's proper and fair because you're not just bolstering what the witness has testified to by saying, oh, and I told someone else, therefore you should believe me today. The cross-examination suggests because of his relationship to the client, to the defendant, that he's lying. If he said the same thing sometime prior thereto, thank you, then it's not hearsay, and it's not used for that improper purpose. Okay? And that's the only time that a prior consistent statement is not hearsay. So, this is another point. Merely crossing a witness about inconsistencies or omissions in prior statements doesn't constitute an allegation of recent fabrication or improper motive. Here's what I mean by that. Yeah, I see this all the time. You cross-examine the witness. Today you said it happened on Tuesday. You remember giving your statement to police, wherein you said it happened on Wednesday. You show it to him, oh yeah, I did. I said it happened on Wednesday. What does the prosecutor want to do when he gets up on redirect? Does this not happen? I want y'all to tell me. Does this not happen to you too? What happens?
Made a mistake.
Huh?
Made a mistake.
No. What does the prosecutor do with the statement? They want to go back through every last fucking thing the guy said that was consistent. Right? Well, if you couldn't do it before you asked about the omission, and before you asked about the inconsistency, you can't do it now. Because merely saying, hey, look, this one fact is different, is not suggesting bias or motive to fabricate on the part of the witness. Oh, and here's my other favorite rule they try to use to get around that. Rule 106. Judge, the whole statement comes in now because he's asking about it. Bullshit, no it doesn't. Rule 106 says that anything that ought to be considered contemporaneously with the part that you've admitted, out of fairness, if it should be considered at the same time, should come in. It's a procedural rule. It says if the rest of it's going to come in, I don't have to wait for you to finish. I can get up and make you introduce it now. But it has to have been something that you've taken out of context. Okay? I like to call this the My Cousin Vinny rule. When the cop is testifying in My Cousin Vinny, and he goes, the defendant told me he shot the clerk. And he leaves it at that. But remember, he really was being sarcastic. I shot the clerk? I shot the clerk? I didn't shoot the clerk. I was at somewhere else when the clerk was shot. It's supposed to be limited to recorded statements, so the metaphor is not perfect, but there's a common law rule of completeness that covers conversations. The point is this: merely impeaching a witness because of omissions or inconsistency between the prior statements and testimony does not allow the rest of the statement to come in. Okay. More disguised hearsay. The prosecutor, savvy enough to know he can't ask somebody, what did they tell you, what did you say? I love this one. The did you at some point learn ruse. Have y'all seen this? Does this happen? Fucking hate it. Officer mouth breather. We were looking for the defendant because we were told, no, defense counsel, objection, hearsay. Prosecutor, officer mouth breather, you cannot tell these good people what other good and honest people in the community told you about the defendant, but at some point, did you learn? No bullshit. Objection, calls for hearsay. Rule 602, lack of personal knowledge. A witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Did you learn something? No. And then what happens then? What did you do as a result of or as part of your investigation trip? Officer mouth breather. Without repeating what someone told you or what you learned, at some point in your investigation, did you have the occasion to speak with residents of the defendant's neighborhood? If you stand up and object, the judge is going to say, no, not yet. He hasn't asked me what anyone said. Yes, I did. Prosecutor. And again, without repeating what those good, honest people said, what did you do as a result of those conversations? We obtained a search warrant for the defendant's residence. Okay? Clear implication is that somebody said something bad that you're trying to keep out. It doesn't matter why the cops did what they did. It's just a disguised way to suggest that something was said that would screw your client. Okay? Still subject to 401 and 403. It probably would be relevant. We'll talk about that when we get to it. But it's definitely far more prejudicial than it would ever be probative. Okay. So, what's another... I want to talk about rules that are misused, and I want to talk about rules that are underused by us. 806. I can't believe this isn't used more. When a hearsay statement or statement that's offered, that's defined in, that's the rule that says statements that are not hearsay, has been admitted into evidence, the credibility of the declarant may be attacked, and if attacked, may be supported by any evidence which would be admissible for those purposes if the declarant had testified as a witness. Okay, all that means is this. If the hearsay statement comes in properly, or a statement which is defined as not hearsay, comes in through another witness, you could effectively cross-examine the declarant, the person who's not there, just as if he testified. Which is only fair. If the shit comes in, anything else that would call that into question should come in too. Right? Prior convictions of the declarant, inconsistent statements by the declarant, bias and motive, opinion and reputation, all of the things that you could cross a person on if they testified, you can get into using 806. Okay. So, let's talk about the confrontation clause and how to federalize your objections. And let me tell you why you do that. I mean, sort of, what I mean by that is, every opportunity that you have to object to evidence coming in or not being able to put up evidence, you should, where at all possible, make a constitutional argument and a federal argument as well. The obvious reason is that if the state's appellate process screws you, then you would have some federal avenues. You know, the likelihood of that ever working out, who knows? But it doesn't matter. You should still do it. But there's another more sort of practical reason to do it. And that's, you start doing that enough, and the judge starts to say, man, this is the lawyer that can maybe screw me. And then the next time you object, you might get something that goes your way. That's another thing aw shucks doesn't get. You know, the lawyer that comes in prepared and actually knows the rules and briefs arguments makes the judge nervous. And he can never get reversed by agreeing with you. You understand what I mean? Because there's no appeal from an acquittal. So if he's getting nervous because you're making a really good record, then he's going to be more likely, he or she more likely to rule your way. All right, Crawford. Oh, man, I don't want to talk about this. A non-testifying witness's statement given at the police station to establish a past crime is testimonial and therefore cannot be admitted into evidence without a violation of the confrontation clause unless the defendant had a prior opportunity to cross-examine the witness. Okay, the big thing that's going to come out of these lines of cases is defining what is testimonial. If it's testimonial, it can't come in unless you had a prior opportunity to cross the witness and that witness is now in favor. Okay? Where testimonial evidence, this is from the opinion. And it's good to, you know, as academic as all this sounds, it's good to actually be able to use the language that comes from the rules and comes from the cases. Where testimonial evidence is at issue, the Sixth Amendment demands that the common law required unavailability and prior opportunity to cross. We leave for another day, thanks a lot, any effort to spell out a comprehensive definition of testimonial. But whatever else it covers, it applies at a minimum to prior statements at a preliminary hearing before a grand jury form trial, police interrogations, all those others are obvious, right? Police interrogations, figuring out what that means and how that's testimonial becomes sort of the crux of arguments in subsequent cases. And at the very least, the Confrontation Clause bars testimonial evidence absent unavailability and prior opportunity to cross, irrespective of the state's analysis of hearsay, or definition of hearsay. Hearsay and Confrontation Clause becoming more and more divergent. They're less and less coextensive. And so where you were in the practice of always objecting hearsay Confrontation Clause, you should probably still do it. It doesn't hurt, but we're going to have to invent newer and different ways to preserve that objection. We'll get that in a minute. So what is testimonial? It's definitely prior testimony in police interrogations, whatever that means. Other possibilities, affidavits, custodial examination, pretrial statements that declarants should reasonably expect to be used prosecutorially. That's the one I like, and I'll talk more about that in a minute. Statements the declarant would reasonably believe to be used as evidence against somebody. Extrajudicial statements contained in formalized testimony, affidavits, depositions, prior testimony, confession. Statements that were made under circumstances that lead an objective witness to believe that the statement would be later used for trial. I like that one too. Oh, what's going on here? We use the term interrogation in its colloquial rather than technical sense. So, not just when someone's in the box, you know, and someone's doing good cop, bad cop, and somebody says something. That's not the only definition of or example of interrogation. Oh, this is what I hate, because this is what we're so used to. We reiterate that when the declarant appears for cross-examination at trial, the Confrontation Clause places no constraint at all on the use of his prior testimonial statements. So what that means is if there is a person in the box with a pulse, anything that you would ordinarily call a Confrontation Clause problem is arguably out the window. I say arguably because I think I can think of some examples where it would still be worth raising. All right, so in the subsequent cases, Davis versus Washington, a 911 call where the declarant was describing events as they occurred did not constitute a police interrogation. Statements were non-testimonial and constituted as they weren't hearsay, whatever else. Admitting statements made to the police on the scene of a domestic call and corresponding affidavit where the suspect and victim were separated came in as excited utterance and present sense impression violated the Confrontation Clause because the statements were testimonial. All right, thinking of these two cases together, the court held statements are non-testimonial when made in the course of a police interrogation under circumstances objectively indicating that the primary purpose of the interrogation is to enable police assistance to meet an ongoing emergency. They are testimonial when the circumstances objectively indicate there is no such ongoing emergency and that the primary purpose of the interrogation is to establish a proof of past events potentially relevant to later criminal prosecution. Make me want to shoot myself. All right, so look, here are factors to look at. Is the witness or listener, the witness who's on the stand, who heard the person say what they said, a member of law enforcement or an agent thereof? That's not dispositive. We'll talk about that in a minute. Statements describing an ongoing emergency versus events as they occur or past events. If it's an ongoing emergency, it's more likely not testimony. If it's describing a past event, it's more likely testimonial. Statements offered for purposes of identifying the perpetrator with a view towards prosecution, more likely testimonial, as opposed to capturing somebody, less likely to. Statements asking for immediate help, less likely to be testimonial, versus the narrative report of a crime, more likely testimonial. Oh, I hate this too. The level of formality in the giving and taking of a statement, okay? The more formal it is, whatever that means, the more likely it is to be testimonial. For example, calmly at the station house to a series of questions with the officer interrogator taping or making notes of the declarant's answers. That's more likely to be testimonial versus frantic answers provided over the phone in an environment where it was neither tranquil nor safe.
Sorry, was that from Hammond?
Let me see. It's Hammond or Davis. Oh, those are the ones that are joint. I think that's right.
Okay.
to make it even more confusing. This is not to say that a conversation which begins as an interrogation to determine the need for emergency assistance cannot, at some point, evolve into a testimonial statement once that purpose has been achieved. In other words, something that starts off testimonial could at some point become an interrogation, and therefore, something that starts off non-testimonial could at some point become an interrogation, and therefore testimonial. Although we necessarily reject the Indiana Supreme Court's implication that virtually all initial inquiries at the crime scene will not be testimonial, in other words, there can still be testimonial statements taken at the crime scene in response to a 911 call. We do not hold the opposite, that no questions at the scene will yield non-testimonial statements. I mean, surely there was a way to say that without so many double negatives. All right, Michigan versus Bryant was the next line of cases, would have been the next case in this line, sort of defining what an emergency is, and still will be. It's the U.S. Supreme Court's grand cert. The state court said that allowing statements from the victim naming his killer after being shot only hours before he died, trial court let him in as excited utterance. The Michigan Court of Appeals or Supreme Court said no, those were testimonial because they were statements to the cops concerning a past event. The event occurred somewhere else, and the threat was over. Thus, the primary purpose of the questions asked and the answers given was to enable police to identify, locate, and apprehend the perpetrator. And the Supreme Court's grand cert, I suspect, would further define ongoing emergency. All right, a different sort of line of case. Giles versus California. Declarant statements recounting domestic abuse incidents to police 3 weeks before the defendant shot and killed her, admitted by the state court under a theory of forfeiture for wrongdoing violated confrontation law. I'm not going to read all that. Forfeiture by wrongdoing is you can't benefit by doing something shitty to somebody else. Okay, so if you kill the person, and that keeps their testimony from coming in, you shouldn't benefit from that. And California's interpretation of that rule would sort of mean that anytime there was a murder case, by definition, the statements made by the murder victim could arguably come in. So the Supreme Court said no. The only statements that we will recognize are those where you can prove that the defendant made the victim absent, whatever that means, either killing them or preventing them from coming, for the sole purpose of, an express purpose of keeping them from testifying. The fact that that just happens to be the consequence of killing them doesn't matter. Melendez-Diaz, the drug analysis, amazing that this was ever even an issue. Forensic reports are classic testimonial evidence and cannot come in absent the ability to cross. This is obviously, a lot of commentators are predicting going to create a huge damn mess. They say, we leave it up to the prosecution to decide what steps in the chain of custody are so crucial as to require evidence, but what testimony is introduced must, if the defendant objects, be introduced live. Well, I mean, that really doesn't answer a whole lot of questions. What about Rule 703 that says experts can rely on evidence that's otherwise hearsay if it's of the sort reasonably relied upon by experts in the field? What if in a murder case the pathologist or ME who performed the autopsy is dead? I don't know the answer to that question. Whether or not somebody else could say, I'm going to give an opinion as to cause of death, and I can do so because I can reasonably rely upon information gathered by the original pathologist. Again, we're showing the divergence between confrontation clause and hearsay. That might not be hearsay, but it can be a confrontation clause problem. Pendergrass versus Indiana was a case that was sort of the next logical question to be asked after Melendez-Diaz, and the Supreme Court denied cert there. The DNA analyst testified to paternity results in a child sex case, relying in part on data collected by someone else. But the key to that, if anybody, was that the other witnesses or potential witnesses that weren't called participated in some level in the collection of the evidence and in the analyzing of the evidence. It wasn't somebody who had absolutely no connection to the case. I think what they did was they called the lab supervisor as opposed to the person who actually performed the test. So look, here are witnesses that might trigger a confrontation clause analysis, things to look out for. Obviously cops, investigators for the prosecutor's office, 911 operators, forensic analysts, sexual assault nurses, social workers investigating allegations of child abuse, EMTs, ER staff, and this is what I say. This is me. Anyone that's collecting information to be used as evidence, anyone receiving information to be used as evidence. Look, this isn't like a Fourth Amendment kind of analysis, okay, where you have to find a state actor. The state action that constitutes the constitutional violation is the proceeding wherein the evidence is admitted, right? Imagine that you have a victim of a violent crime who's been shot and says to EMTs or to anybody, to a private person, you know what? I'm not dying. I know I'm going to live. And you don't have to go catch him because he will turn himself in. I know him. It was my brother-in-law. His name is so-and-so. And I want that motherfucker prosecuted to the fullest extent of the law. Make sure you use this as evidence. I mean, does it matter who that statement's made to? All of these are factors that you should look to because the circumstances surrounding the making of the statement make it more likely that the person should know that they're giving evidence against somebody. But they're not necessary. I love this one. And I really do. Sometimes I'm being sarcastic. I like this one. In the final analysis, it is the declarant's statements, not the interrogation's questions, that the Confrontation Clause requires us to evaluate. That's Davis. And what I really want to emphasize, again, the divergence of Confrontation Clause analysis and hearsay. The business records and the evidence in Melendez-Diaz likely could be business records, but they're still hearsay. Confrontation Clause violation. So with the divergence of hearsay and Confrontation Clause, what else can we do, right? The witness is on the stand, and the judge says, no, you can't cross-examine the witness on bias. They're on the stand. I say that you would still say Confrontation Clause. What does it hurt? But there's also a state constitution that has a Confrontation Clause. So state that as a ground. Sixth Amendment right to effective assistance of counsel. You are fucking me by not allowing me to ask this question. If I were allowed to be effective, I would be able to ask this question. Fifth and 14th Amendment right to due process, state and federal. Sixth Amendment right, fair trial, state and federal. The trial rights, 6th, 5th, 14th. Some courts might say, look, if you just throw that out there just to sort of piss on the record, we're not going to recognize it, but it sure doesn't hurt. It'd be better if you could articulate exactly which right it was. Okay, let's go move on now. And I'm going to say, let's see, I'm going to get to that, right? Give me 1 second. I think all right, screw it. The 600s, impeachment. Any witness, you can impeach your own witness. Everybody knows that, okay? The only main rule that I want to talk about in this regard is just because a party can impeach their own witness, this is one to watch out for. This is one of their dirty tricks. Just because a party can impeach their own witness, and therefore a prosecutor could impeach his or her own witness, doesn't mean that you can call the witness for the sole purpose of impeaching them with a prior inconsistent statement, or a prior statement that they've made that otherwise wouldn't come in. This happens. Witness, usually a co-defendant, makes a statement that says, the defendant did it. I saw him, I was there, he did it. And then at some point, either you get a letter, or the prosecutor gets a letter that hopefully he turns over to you because he's supposed to, or your investigator gets wind of the fact that the witness is now saying it didn't happen, and you get a statement. And all parties know he's saying, I never said that. The cops said that I said it, and I didn't say it, it's not true, it didn't happen. Okay? If you couldn't put that statement in because it's hearsay, right? You couldn't, it doesn't make any sense to just be able to call the witness, have him say, I didn't say that, just so you could introduce it. It's no more reliable, right? And you sure can't cross-examine him on the statement if he says I didn't make it. So there's good case law on this. The leading case from the Fourth Circuit who love screwing people, so you know it must be good. United States versus Morlang. Federal Rule of Evidence 607 permits the party to attack the credibility of any witness, including its own. Although Rule 607 may not be used as subterfuge, if you ever have to research it, that's the word that you find. Subterfuge to introduce otherwise inadmissible evidence. For example, a party may not call a witness solely to impeach the witness with prior inconsistent statements that would otherwise not be admissible as hearsay. The issues. Did the party offering the evidence know of the recantation or denial prior to calling the witness? Well, if you know about it, the other side's going to know about it because you're going to tell them. Okay? How much of the prior statement is now disputed by the witness, and would the witness testify all consistent with the prior statements of fact important in the prosecutor's case? In other words, if he's only disputing or denying part of it, and there's some other part of it that would still be relevant that he is not denying, that would weigh in favor of them being able to call him even though they're going to impeach him. But, and this isn't academic, I've seen this happen. What usually happens is, I don't know what they're talking about. I didn't tell them that. Or, I told them that, but it wasn't true. Does the jurisdiction recognize prior inconsistent statements as admissible both for impeachment and as substantive evidence? That's another factor to consider as to whether or not they should be impeached or witness. Okay, bias. I didn't know this until I was preparing this thing. There's no federal rule that covers bias. In South Carolina, where I practice, we created, I guess, a rule for bias. But I want to talk to you about bias because it should be treated separately than other impeachment. And I'll read that. Extrinsic proof tending to establish a reason on the part of the witness to fabricate is never collateral. That's the key. Bias is never collateral. Remember that. Bias is never collateral. That's what you should say. Those are the magic words. And may not be excluded on that ground. It's axiomatic. Defense counsel should be permitted to expose jury facts relevant to a witness's possible motivation to testify favorably for the prosecution or his potential bias for or against any party of the criminal proceeding. Such information is always relevant to discrediting the witness and affecting the weight of his testimony. Why is that? Look, here's what bias is. I mean, maybe we throw that term around, but bias is the witness's relationship, connection to the subject matter of litigation, which is, why you're there. Okay? Unlike, let's say, some fact about the witness that may be indicative of dishonesty that's not a prior conviction. They were kicked out of school for cheating, okay? Under 608, you're stuck with that answer, right? Because it is collateral. It goes only to general sort of trustworthiness, but not necessarily about this particular matter. Because bias is relevant to this particular matter that you're here for, it's not collateral, and what that means is you don't even have to ask the witness about it at all. You can put up extrinsic evidence of it. You can put up extrinsic evidence without giving him the opportunity to explain or deny, like you have to with a prior inconsistent statement. Bias is never collateral. If you're prone to getting tattoos, that'd be a good one. So, in co-defendants and snitches, they're pending charges, maximum sentence for pending charges, mandatory minimum sentences for pending charges, parole eligibility or lack thereof on pending charges, all of which are going to want to make them testify favorably for the prosecution. Potential life without parole for subsequent convictions. This one, even, South Carolina is hardly progressive. Past pattern of testifying for prosecution and facing charges. We have a case that recognizes this. This scumbag, every time he got in trouble, was cutting deals with prosecutors. You've got to get into that and show his bias. Conditions of prison. Any deal extended by the prosecution requested by the witness's lawyer. In other words, not only offers that they make, but if the witness's lawyer has said, hey, look, he really wants probation, they should disclose that to you and you should ask for it. I don't know what they do where you practice, but where I practice, they stop making deals ahead of time so they don't have to tell you. I think that's a huge mistake myself, because what do you do? I apologize if I'm stepping on the toes of who's going to do impeachment. But you give the best possible outcome where there is no deal. Because every time you do that, almost certainly you can paint a better picture for the witness for lying than what he's really going to get. In other words, if the deal is, look, you're looking at 30 and we're going to make a deal for 10, but they don't make it ahead of time, you want this charge to go away. You're hoping that it's going to be dismissed. anything that could arguably go to his motivation to lie, you get to get into. Prior convictions. This is the only thing I want to say. My group today told me that anything comes in, where is it, Louisiana and Massachusetts? Screw that. The only thing I want you to know is that if your state's adopted the federal rules or you practice in federal court, the thing I want you to know is that the standard for witnesses is different than the standard for a client defendant who's testifying. Okay? When it's the defendant who takes the stand, it should be, and is, harder to use prior convictions to impeach him. And when it's not the defendant, it is and should be easier to use prior convictions. Okay? Here's the language of the rule. I wish they'd just say that, but it's when it's the defendant, the prior conviction is presumed prejudicial. And when it's a witness who's not, it's presumed probative. Here's the rule. For the purpose of attacking a character or for truthfulness of a witness, that's the witness who's not the accused, if they've been convicted of a crime, blah, 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 punishable in more than 1 year, hold on. Oh, that crime shall be admitted subject to 403. I'll go back to that in a minute. But if it's the defendant, evidence that the accused has been convicted of such a crime shall be admitted if the court determines that the probative value of admitting this evidence outweighs its prejudicial effect. Think about that. It comes in if the probative value outweighs its prejudicial effect, meaning it's presumed prejudicial. Okay? You're starting off, it's prejudicial because it's the defendant who's on trial. So if it's the witness subject to 403, it starts off relevant. 403, although relevant, evidence may be excluded if it's unfairly prejudicial. Okay? All I want you to take away from that is, unless you live in a place where they screw you like, where was it again? Missouri and Louisiana, the federal rules, by the language of the rule, gives a different standard for defendants than for witnesses. Okay. Writings and documents. Rule 612, present recollection refreshed. Here's what I want to get. The practical lesson from this is this. Don't just let them throw the witness on the witness stand and sit there and read from their report. Okay? And don't let them just throw the witness up there and casually glance at the report. And I see this all the time. There's a foundation that has to be laid. Okay? Make the witness first establish that the witness lacks the present recollection to recall the event. I was there, but I don't remember. That the document will assist in refreshing the recollection. Yeah, if you showed me that, it probably helped me recall. And they should only review the document to themselves, silently, and not read it. It's almost a legal fiction. It's that I don't remember this thing that I once remembered. If you show me this, then I will probably remember. Oh, now my memory is triggered, and I do remember, and they can testify. But they can't read the document, and the document doesn't come into evidence. And it can be anything. If you want to refresh somebody's recollection, it doesn't have to be something they've written. It can be photographs, newspaper, other recordings. All I want you to know about 613 is before you can admit extrinsic evidence, before you can either admit the evidence, the document, the written statement itself, or before you can call somebody else, you have to give them the opportunity to explain or deny it. You can't sandbag them. You have to remind them that they might have said something different. 8035, past recollection recorded. Make them lay the foundation. Refreshing someone's recollection is, I used to remember this, now I can't remember, but if you remind me, I will remember it now. Past recollection recorded is, I can't remember it now, I know I remembered it then, I still won't remember it, but I definitely knew what I put in the statement when I put it in. So make them lay the foundation again. The witness no longer recalls the event. At some point in the past, they recalled the event, and the document accurately reflects what the witness once knew. The witness has made or adopted the document. In other words, you can't just use anything like with the other rule. And it was made or adopted at a time when the event was fresh in the memory, and the document can only be read and not placed into evidence unless offered by an opposing party. So if you're crossing somebody, then the statement come in. If you're using it through your own witness, you can. The document dance. How to introduce documents with all of the above rules. Okay. I strongly suggest anybody who, and I assume because you're here, this applies to you, tries a lot of cases, that at some point you read a transcript, either of your own trial or someone else's. And it will be difficult, especially if it's your own. because you realize how little sense it makes when you just read the transcript. Or read a transcript that is somebody else's trial and ask yourself, do I have any idea what's going on? You really, it will help you make sure that you say what you need to say. And that's why you would have the document marked for identification. You know, if you're going to show a witness an exhibit or a document, you mark it for identification. This is a defense exhibit, so-and-so for identification, so you can refer to it instead of saying this. You know, every time you talk about it, do you remember this? Have you seen this before? You know what this says? Because this doesn't mean shit, okay? If it's defense exhibit 12, and then you make defense exhibit 12 part of the record, you're not introducing it into evidence, then the record will be complete as to what this would mean if you only said this, okay? So how do you do that? You have it marked for identification. Court reporter marks it. You show it to the meathead on the other side. You see this? See it? So I'm getting ready to use the fuck you. Do you see it? Because you're giving them the opportunity to object to it. You show them, and then you lay the foundation for introducing the document through the witness, asking whatever questions you have to, if you're going to admit it. And then you move it into evidence. Okay? So there's marked for ID first, so you can refer to it, show it to the other side, lay the foundation through the witness. Then if it's going to be admitted, then you can admit it. I will admit that if I know I'm going to get it into evidence, I just have it marked for it into evidence. And this is going to vary from jurisdiction to jurisdiction. I've never had anybody object to it, but technically, the way I just said it is the way I think you're supposed to do it. Make sure they lay the foundation. You recognize this. What is it? And you recognize it because. Error preservation. So look, if you've done all this right, or you've understood the rules, and you're not like aw shucks and just, relying on some kind of Zen quality that you have to, lure jurors into, believing you. If you don't object properly, you've screwed your client again. Make a contemporaneous objection. What that means is you object when the shit comes in that you don't want coming in. Or when the judge doesn't allow you to put in what you want to put in. Okay? And state the grounds. Give a specific and complete ground for the objection. Now here's a practical lesson. What if you're sitting at the defense table and something just strikes you as wrong, right? You're not supposed to do speaking objections. Speaking objections, you know these because prosecutors do them all the time. Objection, he can't do that. Like a kid on the fucking playground, right? Objection, he can't do that. It's a speaking objection. Objection, hearsay. Objection, 404B, okay? But what if something just strikes you as wrong and you just can't figure it out? Do you not object? Shit, no, object. Object, because if you don't, the issue's gone. Object, and then, if you can, ask to approach. And maybe in the few seconds it takes to get up there, right? Or objection, and beg the court's indulgence, and ask their co-counsel. Surely he can't do that. What the fuck's going on? Okay? And get a ruling. We'll go back to contemporaneous. What if you don't object, and then a few minutes later it dawns on you, and you haven't made a contemporaneous? Object anyway. It doesn't hurt. If you figure it out later, do it anyway. It doesn't hurt. It's probably not going to help, but it's sure not going to hurt. Get a ruling, but sometimes less is more. Here's what I mean by that. You have to get the judge to rule, because otherwise the Court of Appeals won't know what to do with it if you didn't get a ruling. Okay? And this is just something that's going to have to come with instinct. You might not always want the judge to explain the basis for their ruling, because if they have discretion and they don't use it, that should be a good grounds for reversal. There are some exceptions to that. If the courts, let's use as an example the balancing test they're supposed to engage in to admit a prior conviction. Okay? If they just admit it and don't engage in the balancing test, it's probably better to just keep your mouth shut. Okay? But if the ruling is so ridiculous, and you've got a judge who's a real idiot, and there are some, then push for it. Okay? But that's just something that's just you're gonna have to just develop an instinct for. So, contemporaneous objection, give a specific and complete ground, and proffer any evidence the judge excludes. If you're not allowed to call a certain witness, if you're not allowed to ask a certain witness certain questions, outside of the presence of the jury, put up the witness or ask the questions. Otherwise, it might not be preserved, Or the appellate court might not be able to assess how you were prejudiced. We don't know what he would have said, you know? We don't know what the answers to those questions would have been. So, also state the prejudice at the appropriate opportunity so that they can't say it was harmless error. Objection, Rule 404B, and then outside of the presence of the jury, explain why it screws you, right? So they can't say or make it more difficult for them to say it was harmless error. The evidence allows the jury to find my client guilty because they think he's a bad person, or prone to act according to his past conduct as opposed to based upon the evidence. That's how I'm prejudiced. Give state and federal grounds, constitutional grounds for every evidentiary objection. My friend who teaches criminal procedure at Cornell broke these down, and I would love to be able to tell you I can explain why there's a difference. But if defense evidence is excluded, 6th and 14th Amendment right to present a defense and comparable provisions in the state constitution. If they put in evidence against you that's irrelevant, 5th and 14th Amendment right to due process, comparable provisions in the state constitution. Admitting evidence that's prejudicial, confusion, or waste of time, 5th and 14th Amendment right to due process, 6th and 14th Amendment right to fair trial, and the state constitution. Character evidence, 5th, 6th, and 14th. Look, 5th, 6th, and 14th, right to a fair trial, right to due process, effective assistance of counsel. I would just throw those out there. To try to determine which ones of those apply, I win, I don't know. Okay, this is the last thing I'm going to do. Motions in limine and when to do them. When to do them. Motion in limine is pre-trial. You know that some shit's coming in that you don't want, right? Or you know they're going to try to keep you from doing something, okay? The main thing to know from this is that if you move to keep out a piece of evidence and that motion is denied, you have to renew your objection when it comes in, or the issue will be waived. And it's another legal fiction, which is that, well, in the course of the trial, the judge surely could have heard something that changed his mind and he or she neglected to tell you, because of course that happens all the time, right? So you have to give the court another opportunity to rule on your objection. But here's the practical lesson that I want you to take away from motions in limine. Your goal as a trial lawyer should be to never have an Anders brief come after one of your trials. And an Anders brief is where appellate counsel says, there aren't any issues here and I need to withdraw from representation of this client. Except if you've gotten everything you want, okay? But there's even some ways to avoid that. Just like you want to establish credibility with the jury, you should establish credibility with your judge too, and not argue everything as if your case depended upon it, not get righteously indignant about every last little thing, as if everything were an affront to justice. If I know I'm right, it's important, I do all the research, I write the brief, I call the witnesses, I have a full hearing on the record, okay? If my client's probably getting screwed anyway and there's something that I might be right about, I'm not sure, then I surprise it with them and just shoot from the hip and kind of hope that it gets denied. So there's something when I'm sitting down there in the holding cell and his mama's crying and his babies are crying, I say, look, you got something. All right, I'm done. Thanks.